Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk about a self-proving will. So what is a self-proving will under California law? So generally, requirements of a valid will under California probate code, the will must be in writing, number one, to be valid. In addition, the will must be signed by the testator or another person as instructed by the testator. So testator is the person who creates the will. And then there also must be two witnesses present at the execution of the will. So the role of the will witnesses is upon your death. So your will likely would have to go through probate if you exceed the threshold of $166,000, $250. That currently is the dollar amount, 166,250. So if you own assets above that threshold and you do have a will, then your will still need to go through probate, and the probate process will need to prove the validity of your will. The court turns to the testimony of the two witnesses who were present when the testator made the will to establish that they either witnessed the testator signing the will, the person making the will informed them that the document is his or her will, the testator was of solid mind and had mental capacity to create the will, and then the person making the will was acting freely without duress. So witnesses could provide this testimony in open court, but in many situations, this solution is impractical. So instead, it is possible to use a self-proving will and eliminate the requirement of presenting testimony in a courtroom.
So what is a self-proving will? So a self-proving will is a will that permits probate court to accept it as the genuine will of the deceased person. In California, a will is proved and is admissible to probate, provided that it was properly prepared and executed according to California law by an adult. At the time the will was signed, the adult must have testamentary capacity and must not have been under any undue influences. Testators may choose to attach a self-proving affidavit to the will that affirms that the will was properly executed. This affidavit should be signed by the testator, the witnesses, and a certified notary public in the state of California. Without a self-proving affidavit, when the testator passes, one of the witnesses will need to be located, and as Jen stated, would have to give testimony in court. They would need to verify the validity of the will. The witnesses may be required to give testimony under oath that the will is valid. A self-proving affidavit avoids all that and can definitely expedite the probate process. So I do have a real life example of this. I have a client who came in with a purported will where the mother had passed and the mother had written in the margins of a document that the house is to be divided among two children. This woman had actually more than two children. I think she had 4 or 5 children, but she only wanted to leave the house to 2 of the 5 children that she had. She signed it and dated it. There is no witnesses, no affidavit, nothing to actually prove the genuineness of the will itself or to show that she had testamentary capacity. So this purported will all wills will need to be probated if the estate has more than 166,000, like Jen said. But in addition, we'll need to show evidence to the court that this is in fact a valid will. And that's going to take a lot more evidentiary things that we'll need to show to make sure that the will is valid and for the court to accept that the will is valid. So all wills are deemed self-proved if they are correctly signed and executed by the testator and witnesses. If there is no contest regarding the validity of the will, the probate court will usually accept it without requiring the testimony of witnesses. A self-proving will eliminates the need for witnesses and beneficiaries to have to appear in court to declare that the will is valid. So if you want to draft a will, or if you have any questions about a self-proving will or anything about estate planning, please contact our office and provide a free 20-minute consultation. And as usual, make sure you subscribe to our channel, and we'll see you in the next one. Thank you.